Good morning and welcome to the Massachusetts Appeals Court on this Wednesday, February 12th, 2025, Abraham Lincoln's birthday. I am Justice Ditkoff. To my right is Justice Hand. To my left is Justice Walsh. We're the panel for all the cases today. I'll go through the basic rules here. We have a clock. You'll have 15 minutes each side. The clock will count down. When there's 90 seconds left, the light will turn yellow. When the time runs out, the light will turn red and start counting up. When it's red, that time is not time you have left, that's time you're over. If the light turns red, please finish your sentence, but don't say anything else unless you're answering questions from one of the judges, in which case, please finish the answer to your question. I assure you that we have read the briefs. We've been through the appendices, we're familiar with your cases, and so you should jump right into your argument. You don't need to give us the background of the cases. All right, with all that being said, I'll call the first case, but before we get going, the first case is number 24P 2018, Commonwealth versus NADEAU. We had a request for instructions on how to deal with the sealed and impounded information in this case, and that's a fair request. And so what we're going to have to do is we're going to have to avoid talking about the sealed information. I understand that will be a disadvantage to all of us because some of it is pretty important to what we're doing here, but there's really not much we can do. The legislature has decided this is sealed, and so we'll just have to avoid that. But don't worry, we know about the arguments relating to the sealed information. We will consider those. Even though you won't be able to say them here. I'll also remind you, of course, that the victim's name is impounded and can't be used in argument. Complainant, victim, any of that is fine, but just not the name. All right, all that done. Counselor, whenever you're ready.
Good morning, Your Honors. Tara Ganguly for Mr. David Nudo. As the court is aware, the court is very familiar with the prior bad acts issue. Without talking about the sealed information, my argument was to talk about the sealed information first. So without doing that, I think this is a good example of a case where the exceptions to the prior bad act, the exceptions to the inability to admit propensity evidence, the exceptions have swallowed the rule. And I cite Justice Singh's dissent in Commonwealth versus Childs a lot, I realize, in my brief, because I think it's important to remind the court, remind everyone that the point of this type of evidence is not to simply admit it. And I admit that I had a hard time finding published cases in support of my argument because the courts generally do seem to admit this type of evidence more often than not. But it is still the exception to the rule against propensity evidence. And in this case,
I think it'd be more accurate to say that we tend to affirm. I think the trial judges are a little more discerning because it is, of course, abuse to discretion.
yes.
Now, you see a lot of cases where prior bad acts were not allowed, and of course it doesn't become an issue because it's in favor of the defendant.
Yes, Your Honor. So the conduct at issue that I'm arguing should not have been admitted here was sandwiched, in terms of chronology of the case, was sandwiched between one portion of charged conduct, then the uncharged conduct, then another portion of charged conduct. And I think it was confusing for the jury in terms of the complainant's testimony, sort of, I don't want to say all over the place, but she certainly did not testify in a way that was fully consistent with the Commonwealth's theory of the case.
So not that the victim may have provided either confusing or inconsistent testimony, but where do you draw the inference that the jury was confused and therefore the verdict as a result of this evidence coming in was somehow affected?
I think the fact that they're, again, Your Honor, I'm not sure exactly what I can say or not, but to say that there was a split verdict, I think that shows that, and it was a significant split verdict in terms of, Your Honors understand. In Commonwealth versus Dwyer, which was a case cited in my brief, the SJC in a split verdict case concluded that there was overwhelming prejudice. You don't have to necessarily go into exactly what caused individual jurors or the jury to believe something versus not believe something else. But in Dwyer, the court said that even with a split verdict, so the Commonwealth argues, well, they could discern, one thing from another. But the court there said, no, in the circumstances of this case, and I'm going to argue this case, we conclude that the defendant has shown the requisite prejudice. Allowing the complainant to testify in detail about each of the 7 certain incidents was excessive. I realize we don't have 7 incidents in this case, but the incident that we did have different parts according to the complainant.
So, Counselor, it seemed to me, and I want to allow you to disagree if I'm misunderstanding the record, it seemed to me that the convictions here were all things where there was corroboration, where either the officers observed bruises or the taser was found. Is that how you take this, or do you take it differently?
Well, so the conviction on count 3, assault on a family household member in September of that year. There's no bruises for an assault charge. Count 5, which was the stun gun count, I admit was different than the conduct in West Virginia that I'm arguing about.
So I thought that Officer Smith observed some bruises on the right arm and thigh, and Sergeant Zev saw a clump of hair in the car. Am I misinterpreting that?
You're correct, but again, this is where we don't know how a jury decides on these things. And yes, that was certainly evidence, but that evidence with respect to a specific charge was not count 3, count 5, or count 11.
Oh.
So,
Can you explain that a little further? I'm not sure I understand why you say that.
so count 5 in the transcript and in the verdict sheet, I don't think I have the verdict sheet in the record appendix, but
So we can talk about the convictions, right? So the
Yes.
assault and battery domestic, the assault and battery, the dangerous weapon stun gun, and then the possession of the stun gun,
Yep.
right? And so you disagree that in those instances in which the jury did convict your client that there was some independent kind of corroborative evidence versus one person saying one thing and one person saying something else?
so with respect to count 5, which is the stun gun, there was the evidence of the stun gun itself in the car, obviously. There was her testimony. His testimony was quite different. The Commonwealth's Officer Diachara was not able to say, yes, this was used on her. He testified more generally about how stun guns operate. And the defense expert, again, jury can believe whatever they want, but the defense expert testified that she did not believe that the marks on the victim were caused by this device. So, and again, count 3, which is just an assault charge, there's not, you can't link that directly to any specific bruises. So the bruises that the officer testified, he certainly testified to them and she testified to them, but They may also have been from a prior incident, whether it was the prior incident from West Virginia, whether it was the prior incident, the other prior incident. Turning to
The ABDW was a shod foot, is that right?
excuse me?
The ABDW was a shod foot, is that right?
Count 5, which is the conviction, the ABDW was the stun gun.
Oh, okay.
Yes.
Mistaken that. Stun gun.
Turning to the issue of prejudice, this was certainly not the most well-given objection, but given how consistently and how strenuously defense counsel filed a motion, there were very long arguments during motions in limine, and when the court finally made its decision, the court made its decision and then immediately pivoted to a different issue, and then trial counsel a few minutes later went back to clarify the judge's decision about this issue. Unfortunately, did not use the magic words of "I object to the court's decision, please note for the record," et cetera. But
I thought I read the Commonwealth's brief to concede that it was prejudicial error, that it was preserved by the fact that it was in the motion in limine.
yes, I have had circumstances where the judges will disagree with me even when there is consistency on that.
And I know I'm known as a stickler for that, so I don't fault you.
But assuming prejudicial error, again, the Commonwealth, this was important evidence for the Commonwealth. The prosecutor used it in her opening. The complainant testified about it. The defendant, who has a right to testify on his own behalf, was therefore forced to testify about it on cross-examination. And then the prosecutor, again, really hammered it home in closing arguments. So we have 4 instances of talking about this conduct. And again, in terms of chronology, the conduct is sandwiched between the charged conduct. Had the court, and I realize it's abuse of discretion, but had the judge made the opposite decision to not admit this evidence, given the jury's conclusions about the case as a whole, I think there's a real question about whether they would have convicted on counts 3, 5, and 11. If there are no further questions, I'll rest on my brief.
Great, thank you so much.
Thank you.
Now we'll hear from the Commonwealth. Whenever you're ready, Counselor.
Thank you. Good morning. May it please the court. Jennifer Cohen for the Commonwealth. The Commonwealth argues that this evidence was relevant for a non-propensity purpose, and I would argue that its most important purpose was to provide context to the relationship, and I think probably the state of mind of the victim. Without this prior bad act evidence, I believe the jury would have been left without an explanation as to why the victim behaved in the way that she did during the September 2020 incident. So I would say that this evidence was highly probative for non-propensity purposes. And of course, that doesn't end the inquiry. We have to look at the record to decide whether the judge weighed the probative value against the possible prejudice to the defendant. And I would say that that did happen here, where the judge allowed the prior bad act with the caveats that the Commonwealth could not elicit testimony regarding the police being involved in the prior bad act incident, and could not impeach the defendant with his prior conviction. Additionally, the judge gave careful and forceful instruction contemporaneously with the testimony and during the final charge. So I would say that given the high probative value and where the judge appropriately weighed and mitigated the risk of prejudice to the defendant, this was not a case where the prior bad act was admitted in error. And I would just say, if the court disagrees and finds that this was admitted in error, I would say that there's still no prejudice to the defendant. It's clear from the record that the prior bad act was not the focus of the Commonwealth's case here. And And again, there was proper instruction given, and I would rest on my brief for the remainder of my prejudice argument.
Do you agree with my view that the convictions are all counts where there was corroborating evidence from the officers?
I do agree with that, Your Honor. We had the images of the victims' injuries that the Commonwealth was arguing were from the stun gun. You have the stun gun itself, and then there was also a clump of hair found outside the car. So I think the evidence supported the verdict here.
And you also, do you agree with your friend, the ABDW is the stun gun, and the domestic violence, assault, and battery could be anything that happened in that September incident?
I agree that it was the stun gun. I think that the ABDW, I'm sorry, the AB assault and battery on a family or household member, I believe that was the pulling out the clump of hair. That's my understanding.
Is that because of the instructions or the way it was argued, or just what do you think naturally?
I think naturally the way that the evidence came in, and I think I have to rely on the way the evidence came in. I'm not entirely sure of the closing argument of the prosecutor.
All right.
If there are no further questions, I'll rest on my brief.
Great. Thank
Thank
you
you.
both. I know it's made it pretty difficult, the situation we're under. I can't say we like it any more than you like it, but I still got a lot out of this case. It was really well briefed and argued. Thank you very much. One sec. All right, calling the second case, number 24P445, Commonwealth versus Henry. Counselor, whenever you're ready.
May it please the court, my name is Stacy Silvera, and I represent the defendant, Bryan Henry, in this conditional plea that's before the court. I wanted to check with the court at the outset. The court asked and counsel both, my brother and I both provided the court with information regarding the Gomez issue and Rule 12b-6, and since it's a threshold issue, I just wanted to see if the supplemental memoranda were sufficient or if the court had questions.
Well, they're very helpful, and I understand everyone, you both agree that we should take this as properly before us. But I am curious, if we don't think it's properly before us, then what do we do?
When I reviewed the issue and submitted to the court, my understanding, looking at the reporter's notes, the rule, which came about after Gomez, was that the, as well as another case, Commonwealth versus Dennis that I cite, was that the motion judge has the discretion to determine if it's an issue that they're going to allow the plea for, whether that information from the Commonwealth that it's a dispositive issue is there or not, and that it's just within, based on the language, the motion judge's discretion. You know, I mean, in terms of moving forward, I'm sure that this is lacking from a lot of these. This is only the second conditional guilty plea appeal that I've done, but I didn't find a form out there like in the juvenile court that you can find that actually has the language in there. So looking at the record, based on, as my brother said, the factual and legal basis given to the judge could reasonably rely on it. I know that doesn't quite answer, I think, your question.
Not even a little, but if you don't have an answer, that's fine. You can move on to your.
I apologize, Judge. I don't think it makes any sense to send it back down based on the record before the court. I think that would just be a waste of judicial resources to go through this whole process again, especially, based on Santabella, the defendants relied on it. With regard to the two issues before this court, the conditional plea, the defendant reserved his appellate rights to his motion to dismiss the indictment for failure to present the grand jury with exculpatory evidence, as well as the motion to dismiss, the motion to suppress in a Franks hearing. With regard to the first issue on the motion to dismiss the indictment, clearly the Commonwealth does not have to provide the grand jury with all exculpatory evidence. The defendant's argument is that it was required to provide evidence to the grand jury of the incorrect phone number in the search warrant affidavit because it went to the credibility of the sole witness at the grand jury hearing, who was...
Would that information have been provided to the grand jury?
So I understand my brother's argument that, and certainly the defendant's not saying that the search warrant affidavit could have come in, but the prosecutor controls the presentation of evidence at the grand jury. The defendant would argue that when the information regarding the execution of the search warrant on the vehicle and the recovery of the cell phone was testified to by the trooper could simply have added more information, a question could have been asked, and stated that when he recovered it, the information, the number in the search warrant that was included in the search warrant was inaccurate, and that if troopers called the different number associated with the defendant and cured the error. I don't think there needed to be more said, but I do think when the Commonwealth decided to put into evidence before the grand jury that the cell phone, was recovered, they had a responsibility to sort of give the grand jury a complete picture.
And what would the effect of that have been? Simply to indicate that there was some reason why the grand jury shouldn't credit the testimony about what was discovered on the execution of the search warrant?
Yeah, the testimony at the grand jury went directly to and you mean the execution of the search warrant to the house?
Either.
To either. Well, I think the evidence would go, when I say it goes directly to the credibility of the sole witness, the affiant, I think that's where my brother and I, if this is what you're getting to, are arguing about whether this is just a clerical mistake or it's material to the entire affidavit. The defendant argues it's material. The entire affidavit is based on the personal knowledge of Trooper Frace, who was at least at three of the four controlled buys detailed in the affidavit, and he claimed in the affidavit that the judge relied upon, that he had personally had the information of the correct phone number, the 508 number, and he relied upon it, the fact that it was not the correct phone number, and used it prejudicially against the defendant.
So I understand that, but I think what I'm having trouble seeing is if in your universe or your perception of the way that the information should have been presented to the grand jury, it would have been presented as there was a mistake with the phone number. It didn't correspond to the phone number of the phone found in the car, and that's the information the grand jury would have. Yeah, just that. I don't necessarily think more was needed. I don't think. How would the grand jury, though, from that point of view, how would that, other than?
It would show a mistake.
Okay, but how would that impact? But the grand jury didn't hear about the search warrant backdrop, nor were they going to.
Correct.
What they heard was the search warrant was executed and these items were found. And is it your perception that or your argument that the fact that there was a mistake with the phone number would cause the grand jury to doubt whether those items were found as Frace testified to?
No, I know, Your Honor. I mean, I do agree with your contention on that. It doesn't go towards the items removed from the house. But I do think it does go to the actual credibility and the weight that the grand juries would have given the testimony of the officer in determining whether to hand up the indictment, because here it was a very short presentation. The grand jurors had numerous, I don't know if it was 7 pages, the grand jurors had numerous questions regarding whether they could hand up the indictment based on the information they had that True Narc field test actually said the substance could be fentanyl or a fentanyl compound, or it could be methamphetamine. And this 50%, I realize my brother has argued that that's sufficient evidence. The defendant argues it's weak evidence in that it doesn't suggest one drug more than the other. The powdery substance, I'm sorry.
No, that's okay. I mean, with
the
respect
powdery
to that,
substance that was recovered from the house could have easily been methamphetamine. There was testimony by Trooper Frace, who wasn't qualified as and didn't need to be, I suppose, for the grand jury, as an expert, and didn't use the consistent with testimony that any residue would be fentanyl and with cutting agents, maybe on the blender. Beyond that, I think it's probably common knowledge to the jurors that people use cutting agents for different drugs, not solely for fentanyl.
But all the
So-
testimony was related to fentanyl, with the exception of the reference to the dual potential for the true narc result, correct?
Right, yeah, I mean, generally speaking, and the money, I suppose, the $4,000 that was recovered, which would be an accoutrement. But, for the defendant's point, that was the evidence that was there, and it was an unfair presentation by the sole witness, and to at least provide the accuracy of what happened with the search to the cell phone. I suppose if the Commonwealth had not hypothetically entered the cell phone, maybe I wouldn't be making that argument, but they did, and once they decided to enter the cell phone, given the fact that they were aware it was exculpatory evidence as far back as the day on September 21st that the police executed the search warrant, realized it was the wrong number, and somehow communicated with the district attorney's office so that at the district court arraignment, defense counsel was informed just prior to the arraignment that day that the actual warrant affidavit had the inaccurate phone number. I'd like to...
Can I interrupt for a moment? I guess I'm having a little bit of a difficulty understanding your argument in this way. Is your position that any mistake, honest or not, by the sole witness before the grand jury must be disclosed?
No, I think that the position is that this particular mistake went to the sloppy the sloppy police work, which, I think the motion judge found.
So in a hypothetical, if they thought it was a white Toyota RAV, but in fact it was a silver Toyota RAV, would that have to have been disclosed? Would it have mattered, in other words?
It would, I suppose, only have mattered to the search of the vehicle if the actual remainder of the description of the vehicle the defendant was driving that day was not the actual vehicle described in the search warrant with an actual license plate number.
So in this instance, picking up on Justice Hand's questions, the telephone number, I'm still having some difficulty comprehending. You think and suggest that the failure to provide the correct telephone number was something more than sloppy police work, whether it was an honest mistake as a result or something else.
Yeah, with regard to the motion to dismiss, I guess it's just that it would have impacted the credibility of the only witness testifying before the grand jury. And then when you move into whether that we have the Franks hearing was allowed, at that point, we're looking at, we haven't really gotten into it, and my brother argues about whether this is clerical error or material. This is not a case. When you look at the search warrant, if this was a clerical error and we looked at the the search warrant for the house, maybe it would say 139 Chandler Ave or Channing Ave, whatever it was, versus 137. There's also a description there, and the description would tell the officers that they're searching, a single-family residence with a gray roof and gray siding. Where you look at the phone number, the only description, which is why I argue it's different than something like that example, is the phone number. The confidential informant just identified an unknown black male that he called this one number for. He said the defendant was 6 feet. The defendant's actually 6'5", which is quite a difference. So really, the confidential informant hadn't been to the house. The confidential informant. There were 4 controlled buys, but when we're looking at the Franks hearing, I guess, I think the materiality and the centrality of the omitted of the phone number is central. And if you take that away, I'd argue that if the judge was aware that the phone number was incorrect when presented with the warrant, the judge would have a reason to question the credibility of the actual, confidential informant who apparently hadn't been used by the police before, and would also be able to question the credibility of the affiant. The affiant would have provided, the judge would have known that the affiant provided a warrant affidavit that he repeatedly not only used the incorrect phone number, but said he had personal knowledge of it, and the fact that it was not the defendant's number was actually used against the defendant as evidence he was, in fact, somebody who distributed drugs.
But is your argument that it can't be a clerical error because the information was too important?
I'm sorry.
Is the issue that it can't be we should reject the Commonwealth's argument about the clerical error because the information was too important to be a clerical error?
Yeah.
Okay, but then, if I'm understanding correctly, you're saying if we don't accept the clerical error argument, then it becomes a reckless misstatement.
Yeah, that it's
But
material.
isn't there a middle ground, is my question. Like, why is it not negligence? Why in these circumstances, despite the fact that it may be important information, I'm not at this moment entirely convinced by the argument that it must therefore be
At least
a reckless misrepresentation or a reckless misstatement of fact.
You know, I think, I guess in this case, I would look at the totality of the circumstances and the fact the affiant was actually the individual who, it appears to me, discovered the mistake with Trooper Morrissey, and I think the affiant might have called the cell phone. The affiant is central to this, so the fact that the affiant is not disclosing, a part of his police work that was not checked when the warrant application came forward, that's where I also find it's material to this case. I'm sorry, I'm not sure. I see, Your Honors, that I have 1 minute left. Is there any other specific questions that I could answer?
I have some technical questions. On page 43 of your appendix, there's a TrueNarc printout. Where is that in the record? What was that? How was that presented to the trial judge or the motion judge?
The TrueNarc scan was not introduced at the grand jury. It was, I think, provided in discovery. So I guess
How did the judge see it, though?
How did the motion judge? I don't know.
Any judge involved in this
I don't believe
case?
any judge. I think I provided it just to show when I was arguing that no one actually said the exact, no one provided the grand jury with the fact that it was fentanyl compound versus methamphetamine.
Right.
I think there were a variety of things said, fentanyl versus methamphetamine
So then there's
compound.
a picture of a TrueNarc. Is that also not in the record?
Yeah, the pictures were not. All that came in at the grand jury to the grand jurors was the fact that the TrueNarc, it was oral, that, the officer conducted a TrueNarc field test, and based on that.
Yeah, no, I'm just trying to figure out what in this appendix is actually in front of us. There's a FRIAS report, December 7th, 2022. Is that in the record
That
on
is
appeal?
a supplemental police report that was introduced, I believe, by my brother at the hearing before Judge Halal as part of the presentation. That was the police officer's attempt to cure and explain the mistake that they realized on September 21st.
All right, and there's a police report from July 8th, 2022. That's the same thing?
A police report from July 8th.
And on page 49 of your appendix, there's an earlier police report from July 8th, 2022. Is that also?
I apologize. It appears I may have included part of the discovery that was provided. It did not. I don't believe the police report came in at the suppression or dismissal hearings before Judge Halal, and it did not come in, to the best of my knowledge, at the grand jury proceedings at all.
And finally, there's a drug cert. I assume that came in at the trial?
There was no trial here, so
Oh, right, of course.
The drug cert came back. There was testimony. Part of this is I apologize, Your Honor. Dealing with the conditional guilty plea, I apparently made a mistake. The drug cert, there was testimony at the grand jury that the Commonwealth had put forward and sent the drugs off to be certified. Counsel was provided with the later drug cert when it came back, but that was after the grand jury proceedings, which occurred in mid-October.
All right. Thank you.
Thank you very much. I'd rest my brief.
All right, thank you. We'll hear from the Commonwealth now.
Good morning, Your Honors. Arne Hans for the Commonwealth. With respect to the defendant's claims on the motion to dismiss, it's clear that the cell phone is not material to the case that was before the grand jury. The cell phone was certainly a part of the investigation on the 4 controlled buys, and we can get into that in the second part, the motion to suppress. But it has no bearing on what's before the grand jury, and that's the narcotics that were found at the execution of the search warrant in the defendant's home. And no false or deceptive information was actually presented to the grand jury. They stated that a cell phone was recovered from the vehicle because they executed a search warrant on the vehicle as well, but they don't talk about the number or why it's important. And in order to validate the defendant's claims, they would have had to go into all these inadmissible prior bad acts, which they were never going to get into because it's the standard practice in these types of cases to not indict the controlled buys for fear of burning the CI, because those people, if their identity is revealed, are put in great danger.
Would you agree that the evidence about the mistake would have some potential to undermine the credibility of the testifying officer?
I think it's a very human mistake. What happens is Trooper Morrissey is handling this CI, and that CI is buying it from two different targets, one that Trooper Freyas is investigating and one that we don't know. And they do these concurrent investigations, and when it's time to write the warrant, Trooper Morrissey makes a human mistake, and I would say it's negligence, gives the wrong information to Trooper Freyas. And they realize it when they execute the search warrant. They call the number, it's the wrong number, and Morrissey realizes almost immediately, oh, I think I know where this went wrong, puts in the correct number and says, look at that, it's just a transcription error. The record still reflects that the defendant's phone number was used to set up the controlled buys. But even if they were to find a phone that doesn't match either of these two phone numbers, so the phone doesn't link the defendant to either crime, it doesn't really matter because they set up 4 controlled buys and they witness the defendant going to and from these 4 controlled buys, and they're able to establish his identity and his involvement in these crimes through their firsthand observations.
Without disputing that analysis, the question still is, if the jury had known that there was a mistake that the police had made, sloppy or otherwise, or assumed sloppy, and that the police had then explained that, had built on that, used that mistake to build a stronger argument, arguably, for the defendant's involvement in drug sales, would you agree that that might have some impact on the jury's assessment of the overall credibility of Freyas at the grand jury?
I don't think so. This is such a small mistake, plus it's not even Freyas's mistake. It's the mistake of another trooper. And the evidence against this defendant was so overwhelming. Again, the backdrop of it is they do 4 controlled buys with this individual he's seen going back and forth to his house, but then they get to his house and he has a substantial amount of fentanyl, a blender, cutting agent, as well as $4,000 US cash. His mail is in his room. His mother says that's his room. There's a lot of evidence that ties this defendant to trafficking those narcotics.
I guess my question is, though, even if it weren't this particular case, overall, the fact that it might be tricky to introduce evidence that suggests that the Commonwealth, that the police in this instance, had made a mistake, that insulates the Commonwealth from the obligation to provide that information to the grand jury?
So the Commonwealth isn't even required to provide exculpatory information. I don't see how this phone number is exculpatory in any sense. And to explain that, you would again have to present the grand jury the facts of the case and all of the prior bad acts. But the fact that they put the wrong phone number in, realized it after, immediately corrected themselves, and then at the arraignment immediately told the defendant, hey, we put the wrong number in, I don't see how any of that's exculpatory. The phone still links them to the crime.
Why isn't it exculpatory that the officer, through inattention, got the phone number wrong? I'm not saying it's really important, but why isn't it exculpatory?
I don't see how that would negate from the defendant's guilt in this case. Plus, it's clearly negligence, and the standard here
Doesn't
is...
everything that hurts the credibility of a Commonwealth witness exculpatory? I mean, isn't that just basic?
Yes, from a strict sense, yes.
All right.
Now, with respect, it needs to be, Commonwealth needs to recklessly and knowingly misrepresent the information, and that really wasn't here. Because, one, it's not relevant or material, the case that was before the grand jury, and clearly it's negligence. Now, with respect to the motion to suppress, there's a very clear nexus between the defendant, his car, and his home, and his drug dealing. They set up 4 controlled buys, so that provides veracity as well as basis of knowledge. They make firsthand observations of the defendant. They're able to identify him by running the RMV registry for the car, find out it's his mother's car, look up the mother's address, find out the defendant lives at that address, and they're able to identify him that way. They follow him back and forth. So they see him leaving his house the last 3 control buys, and they see him returning to his house the first 3, they cut off surveillance on the 4th because they thought maybe they would get spotted. So there's a clear nexus there. There's also a nexus to the car. The DeFrancesco case is very clear that irrespective of whether or not you believe the drugs are being stored there in the car is clearly being used to facilitate the transportation of the drugs as well as the proceeds from the sales to and from the defendant's home. Does the court have any other questions?
I got a few questions about the 12b6 issue. One is, I understand you both believe this is properly before us, and you may well be right. If it isn't properly before us, what in the world do we do?
So I think that the decision the court would then make is say that the conditional plea didn't match the rules, and I think the plea would be void, the conviction would be vacated, and then it would go back to the superior court. I think from a practical perspective, we'd end up going through the exact same motions here, and we end up adding a paragraph saying that these are dispositive issues to the joint memorandum, which is essentially what defense counsel and I have already agreed upon. And
You agreed that if the suppression is granted in total, your case isn't viable. Obviously, it's dismissed, it's not viable. But I assume that's not an agreement that if it was just the car search that was suppressed, the case would still be viable in that situation.
Correct, because again, the only thing that was found in the car was the phone, and the phone doesn't really have a bearing on the indictment.
And on the other side, if the only thing we found that should have been suppressed was the house search, it would make your case not viable, right?
Correct, because all of the drugs were found in the house.
All right, I get it. All right, well, thank you both.
Thank you.
It's an interesting case, and we're very appreciative of the briefing and the argument. All right, do we have Attorney Sacco? We do, excellent. The third case is Sibley versus Contributory Retirement Appeal Board, number 24P 741. Let's just give a second for your friend to unpack before we start. All right, looks like we're ready. Whenever you're ready.
Good morning. May it please the court. My name is Catherine Lamondia-Rinkel. I'm an attorney with Lebos Law, and I represent Michael Sibley. Mr. Sibley is currently 71 years old. He's a former laborer truck driver with the town of Northfield, having worked for them for 15 years, excuse me. We're here today as a result of the denial by CRAB of his application for disability retirement. There are several components to my appeal.
Before you jump into the appeal, could you walk me through sort of the impact? What kind of benefits is he entitled to if he doesn't get the accidental retirement?
Certainly. So the accidental disability retirement essentially gives a worker injured within the context or the framework of the Chapter 32, Section 7, which we'll talk about in a little bit, gives them 72% of their average weekly wage, tax-free. So it has some significant tax advantages, and it's essentially paying them 72%. As state employees, you're probably familiar that for some people to get rates that high, they need to be within the system for, 28 years, 26 years, a sufficient length of time to qualify for that type of benefit, and then they don't get the tax advantages that an individual who qualifies for a disability retirement would.
And could you give me some sort of ballpark idea of, what he's at if he just has a normal retirement?
He had only had 15 years, so I'm going to guess he's probably about 34, 35%, somewhere in that range.
It's quite substantial.
It is substantial.
Thank you very much. That's really helpful.
I come from the background of having a workers' compensation practice, and so I look at this case as a disability retirement and a workers' compensation claim, for the most part, go hand in hand. There are exceptions for when somebody injured in the course of employment would not qualify for a disability retirement. That's that's for another day. I'm going to focus on specifically with respect to the cumulative stress type claims that I have here. when you look at the definition of personal injury, and that's really talked about, the entitlement to benefits comes from this Chapter 32, Section 7, which provides for accidental disability benefits for any member who has been injured by reason of a personal injury or a violent act injury sustained or a hazard undergone as a result of and while in the performance of the member's duties. And again, it goes on to talk a little bit more about the statute, but for sake of time. The Workers' Compensation Act also references personal injury, when an incident is arising out of and in the course of employment. And the Workers' Compensation Statute, which I'll reference as Chapter 152, has gone on to define personal injury a little bit further via legislation that started to happen in 1991. And so there are some specific definitions that now apply to personal injury in the context of a workers' compensation claim, but they're not all-inclusive in terms of what's in the statute. They look beyond. And so here we have this Chapter 32, Section 7 accidental disability statute that references the word personal injury. And we have Chapter 152 that references personal injury when someone's entitled to workers' compensation benefits. And both those statutes have a similar purpose, and that purpose is to support injured workers who have permanent disabilities and can't go back to work as a result of being injured performing the essential functions of the job.
But the laws aren't identical, or the mission and purpose of workers' comp and kind of the retirement and accidental disability aren't always exactly aligned, correct?
That's very true. And so workers' comp has a lot of temporary benefits that are available, and to get people back to work and to retrain them. But when you're looking at somebody in Mr. Sibley's particular situation where he can never return to doing the type of work he did before, he's permanently disabled, those two statutes should align with the same purpose.
So when we drill this down, you agree that the issue really is that third element, correct, on the prima facie case?
Correct.
And so the question of whether general kind of wear and tear on a body or cumulative type of stress type of injuries seems to lead us to whether or not this identifiable condition, which is not defined, that whether it's not common and necessary to all or great many occupations, correct?
Correct.
So I appreciated your brief. It was very helpful. Where I got a little bit confused, and I'm hoping you can help me with this, is your argument that the board made an error of law, or is your argument that there was not substantial evidence? Because it seems to me that it's Sibley's burden of establishing the prima facie case. So, or is it both?
It is both.
Okay.
And that's,
What's the error of law that
their misinterpretation of the word personal injury and their application of identifiable conditions. And so that's where I started. We have two statutes, two similar purposes in at least Mr. Sibley's case. They both go back to Surofsky. It all starts there. And the retirement board looks at Surofsky and says, here's where it starts. And then from there they diverge. And our position is the way CRAB is applying identifiable condition is a misinterpretation of what the intent was meant to be. And if you look at the case law and you look at where it's tried to go, in fact, DALA in this particular case applied the definition favorable to Mr. Sibley, and CRAB ultimately overturns that. But if you look at it, it's not meant to be a unique task. If we were to apply the definition that CRAB wants us to apply, then we essentially exclude a whole bunch of people that gave their health for their job, that there'd be a very limited set of circumstances when the identifiable condition language that CRAB wants us to use.
You argue that, but then on the other side, I hear that if we were to accept your interpretation, every individual who does thank heavens they do, but hard physical labor for a long period of time would also kind of be entitled to.
Well, and I'm sure that's the floodgates that Attorney Sacco is going to argue in support of his position in the case, but I really don't think so, and the reason why is because you still have to look at the circumstances as a whole. In this particular case, which makes it so very distinct, is Mr. Sibley has two massive, unrepairable rotator cuff tears. This
Not the
is
extent of his injuries, but the conditions of his work. So in other words, his identical condition that is not common and necessary to all or great many occupations, the kind of lifting of the drains, the heavy pushing over the heads. I am not dismissing, but you've proven his permanent injury by two ruptured rotator cuffs, certainly. But those activities seem to apply to so many occupations that require people to physically, firefighters, for example, right? That was one of the examples. Lifting heavy objects and moving and pushing, and custodians. I know you take issue, but it's the job itself, isn't it, that we look at? Not the injury necessarily.
Well, it is one component that we look at, but not all jobs are performed the same. And we know to dismiss someone being a firefighter, but being a firefighter in a more rural community may be less strenuous than being a firefighter in Springfield. So even within one's own job, there are different elements of how intense that particular job is going to be performed.
So I guess what makes this job different from normal hard labor wear and tear in this record?
Intensity, frequency, his job description requires that he be able to perform strenuous physical work to do his job. And that's what he did every single day. And I think that that makes it unique. I'm not sure how unique we need to go, because I think the case law suggests that it doesn't need to be unique, but they need to look at the intensity and frequency of the job. And I'm sorry, I need a little bit of water if you don't mind.
That's why we have it. I couldn't go a full argument without some water when I was arguing for a living.
As I spill it, would not be good for any of us, but tend to be a little klutzy. So it's the intensity and frequency with which he did his job. This job description required physical strenuous work from him. I think the fact that the injury that he had, coupled with the description, plays an important role. And we go back to, why doesn't this open the floodgates? Because in a lot of the cases that were denied, we're dealing with degenerative disc disease. And yes, I know there's an argument that you can make that heavy physical labor or repetitive work may lead to degenerative disc disease. That's not going to be in every case, and that's up for the medical evidence in that particular case to support that diagnosis and to be coupled with the intensity of the job duties performed by that particular individual. Some of the other cases just talked about osteoarthritis. A lot of the cases that Crabb relied on were denied because of the diagnosis. They were more arthritic, they were degenerative. In Mr. Sibley's case, he didn't have that, and that goes to my next argument, the substantial evidence test. He had these massive bilateral rotator cuff tears. His life would have been so different if he had two incidents in mind and he reported these as two specific incidents, but he didn't. And I think that's an argument to how hard these people work. They have aches and pains every day of their life. They ignore it, they go on. And now when he finally hits the fan, so to speak, he can't do his job anymore. And he's told, well, because you didn't report incidents and you didn't complain about every bump and bruise, you don't get it because it's not an identifiable condition. And that's our argument. It's just wrong in terms of how they're defining it. It makes no sense that they've taken Zorofsky and gone left when the Workers' Compensation Board has gone right. The Adams decision says we should be looking at how workers' comp has defined personal injury, looking at their cumulative stress cases, adopting some of that language, and we clearly still have Crabb denying that at this very time.
In part because of the application, right? I mean, unfortunately, had Mr. Sibley applied and said, I lifted a certain grate, and as soon as I did, I heard the popping and I couldn't move my right or left shoulders, and this is what happened, then we wouldn't be in this, what you consider lose-lose situation of identifiable condition. That
Right.
he'll never be able to qualify as an identifiable condition because of that. I understand.
And we talked a little bit about, what makes the difference between a custodian or a firefighter, and can we compare those to Mr. Sibley? And that goes to my substantial evidence argument that there really probably wasn't enough of a comparison and enough in their language to justify what they said. In two of the cases they were relied upon, those people were given medical panels. Mr. Sibley was not afforded the benefit of a medical panel to even get the opinion from this panel about how it related to his work.
But where is your evidence, since it's your burden to establish a prima facie case, of that identifiable condition not common?
Because I think I've done that, by the physician statement. I've put forth, a physician statement checking off the 3 boxes. I've gotten a job description that shows that this is a job that requires strenuous physical work to perform all of his duties.
Right. No argument that that's a job that requires physically hard and challenging work.
And then he's,
Your burden of proving that it's not common and necessary to all or a great many occupations. What's so different?
but isn't that why we're here? It's the subject of interpretation. What does that mean? And where workers' comp has defined it to mean it's not going to be the wear and tear activities of standing, bending, walking. It's something different. And Mr. Sibley was at his hearing. He was testifying about his work. His employer was there, or the employing unit was there. That should have been sufficient to get him to a medical panel to then have the medical panel address what work activities, or are his work activities attributable to what happened to him in this given situation, and he wasn't afforded that opportunity.
Do you want to, and it's okay if the answer is no, do you want to address the board's notice argument, the tail end of their brief? It's okay if you don't, but I do want to give you an
Only to
opportunity.
say I've never really seen that as being an argument, because my initial argument, I think the one that Dalla accepted, was that he was exempted because he had collected workers' compensation. It was based upon the same theory, the cumulative stress theory. Crabb came back and also gave us the exception to the notice requirement by saying that he had essentially performed these duties within the 2 years. So again, the notice wasn't applicable. So I've never really felt the notice argument was a strong one in defense of the case, but that's my position, and I'll rest on what's in my brief for the remainder.
All right, thank you very much.
Thank you.
We'll hear from the board now.
Good morning. May it please the court, Michael Sacco on behalf of the Franklin Regional Retirement Board. I guess I'll continue with Justice Walsh's theme, which is this is not a workers' compensation case. This is very clearly about what constitutes an identifiable condition. And none of the appellate courts in the Commonwealth have ever discussed what constitutes an identifiable condition, other than the Blanchette case in a footnote where it talked about perhaps the exposure to asbestos that resulted in asbestosis, mesothelioma, that type of a hazard. When the retirement statute talks about a personal injury or a hazard undergone, and this is not a personal injury case, even though Mr. Sibley checked personal injury, what he said essentially was, my entire career of cumulative heavy work resulted in my permanent incapacity. And to his credit, he didn't go back and try and find an incident. So I give him credit for his honesty, but his honesty, I think, has disqualified him from receiving an accidental disability retirement because, as Justice Walsh pointed out, his job is no different than hundreds, if not thousands, of other jobs in the Commonwealth. When you look at what was listed as his duties, filling potholes and catch basins, I'm pretty sure there are streets and gutters and sewer systems in every municipality in the Commonwealth. There are literally hundreds and thousands of people who perform these strenuous duties, which we admire them for, and we need them to do these jobs. But the case law simply has not recognized that it's an identifiable condition, not common and necessary to all or a great many occupations.
Okay, but, sorry, go ahead.
One is going to have to.
So there's something troubling, at least for me individually. We're talking about having Mr. Sibley evaluated by a medical panel, right? We don't even get there.
Right.
It stops, and why is it not enough with the evidence that was presented of two massive ruptured shoulders, right, or rotator cuffs, and the medical testimony to say, I mean, what more does he need to do to show, how could he ever get to a medical panel by checking off honestly that this was a hazard undergone, that this is an identifiable condition? Can you explain to me where he would ever be able to get to a medical panel as a preliminary matter to have them evaluate and then discern whether he qualifies?
Sure, Your Honor. So an identifiable condition is a legal issue, not a medical one. Medical panels don't decide what's
right.
Right? So if
Right,
there's no...
so tell me how someone in Mr. Sibley's shoes with an rotator cuff, not asbestosis, because I saw the footnote in Blanchett, could ever get to a medical panel with those types of injuries.
He can't.
Right.
I mean, that's just,
Right.
and that's just the way that the law has been interpreted, that if you, and we cited, it's cited in Zarofsky, which, as my sister said, started this whole identifiable condition, you know, and here we are 40 years later, and there's never been any further expansion of, or even definition of what that means, but what it can't mean is simply doing physical labor is an identifiable condition, because it is common and necessary to all or a great many occupations, whether you're a custodian, whether you're a firefighter, whether you're a DPW worker, or any host of physically demanding positions. And while it may seem unfair that someone accepts this job that's physically demanding and their body breaks down, the case law going back, which was cited in Zarofsky's, Spala's case, and Doyle's case, and Burns's case, has always stood for that proposition that just performing your duties over a period of time is not compensable. It wasn't in the workers' comp context, and it certainly is not compensable in the retirement context.
No, but your sister's point about oftentimes in this field of work that requires physically demanding jobs, individuals get up and they work in pain every day. And it's not until that final straw that breaks the camel's back that they're unable to do it, that they don't say, oh, it happened on August 15th when I lifted this heavy object, because we wouldn't be here, right?
That's correct.
That's all I'm saying, is that the purpose of the accidental retirement is the disability is to compensate people who are injured on the job as a result of their work. And had the box number 2 been checked off, then he would have gone to a medical panel.
No, I mean, even if he said it was a hazard undergone, we would have conducted the same analysis and reached the same conclusion, which is that the physical labor, which has a cumulative effect over a period of time in the absence of a specific injury.
Right, but if he said, when I say about, if he had said, I lifted up this grate, and as soon as that I heard the popping of my shoulders, and I couldn't even lift, my hand.
Yes,
right.
yes. And Your Honor, to that point, and not in the record, but I stand here of someone who's had 3 rotator cuff surgeries. You know when you tear your rotator cuff, because it hurts, and you hear it. There are also degenerative tears that occur over time, which, again, none of this was developed below, because we all agreed that because of the bilateral massive rotator cuffs, he was clearly permanently disabled. There's no dispute there. This is all about causation, and it's about error of law, not substantial evidence. As you pointed out, Your Honor, and as the Superior Court did down below, the burden was not on Crabb to show that there are other jobs that are similar than as Mr. Sibley's, but it was his job to show how is his job different.
Could Mr. Sibley have shown, I hope I'm not mischaracterizing Attorney Lamondia Wrinkle's argument, but could Mr. Sibley have shown that his job was different had he provided some greater objective contrast between the intensity of his work, which in fairness to Mr. Sibley is described as extreme, and other types of jobs that, I mean, if he's supposed to knock out jobs that involve some aspects of the same types of manual work, but not with the frequency or the intensity or the regularity of the work that he's doing, could that have made a difference in his case?
Well, I
Or
think
is it just the nature of the work?
I think it could have made a difference. I can't say dispositively that it wouldn't, but what I would say to you that is if you decided that that was necessary, and again, they opted to not have a hearing and present the evidence, so I don't think they get a do-over simply because they made the election to go forward without a hearing. But had there been a hearing, and that was the argument, I can tell you as board counsel, I would have requested job descriptions for similar positions from the other 350 municipalities. I've been doing this for 35 years. They all would say the same thing. It's an intense job. I mean, these physical laborers, are not sure. Sometimes you drive by the hole and there's 3 of them standing there. For the most part, they're working really hard every day, and it's physically demanding. But it's no different than, I disagree that the frequency and intensity in this case, certainly on the evidence before you, demonstrates that it's an identifiable condition. But I also would suggest that even if given that opportunity, I don't believe they could satisfy that burden, because this is the job, just as the Laura case, which is cited in my brief and which I provided to you in the brief, which was a very similar case, physically demanding, working in holes, standing in water, cold elements, putting pipes in, same result. And that was in Taunton. Now this was in Northfield, I believe. So we're talking about opposite ends of the states, a city versus a town. It's the same job. I would argue that it's less frequent and intense in a smaller community than it would be in a larger municipality, but the job is the same. And that's really the point here. And my sister's right. This would open up the floodgates. This would essentially create a presumption that if you have a physically demanding job and you somehow end up with some physical impairment, that you're entitled to 72% tax-free for the rest of your life. And that is, this case is more than about just this case, depending on how you decide, of course, but this could open up the floodgates with respect to the accidental disability retirement and a burden that is borne by the retirement system and then derivatively down to the municipalities.
Did Laura, can you refresh my memory, did Laura analysis include a stop at the medical panel, or was it a decision?
He did not go to a medical panel. And the reason, and I don't know if it's cited in the briefs, Your Honor, I can follow up if you'd like post-argument, but the PERAC regulations, which are the regulations that govern disability retirement from our oversight authority, state specifically that at any time that as a matter of law an individual cannot prevail, they're not entitled to a medical panel. And the Damiano case, which this court decided, was that case. So it's not unusual that you wouldn't go to a medical panel. I think most times you do if there's a question, certainly a factual dispute, but on a legal question, the simplest ones that I've seen is someone's walking out in the parking lot on their way home, go into their car, trip and fall, injure their knee. They're not in the performance of their duties. They don't get a medical panel. Because as I said earlier, the reason why we don't go with a medical panel in this case is because the medical panel is there to assess medical issues, not legal ones. And this is clearly a legal case. Unless the court has any other questions, I think it's pretty clear in this case that what Mr. Sibley did was physically demanding and strenuous, but no different than hundreds of other jobs. It can't be considered an identifiable condition, and we ask that you affirm the Crabb decision. I will mention just briefly on the notice issue, I think what we took issue with Crabb, and they're not here today, obviously they devolved and are not participating. When we talk about notice in the retirement statute, what the law says is that unless there's a notice of injury or a receipt of contemporaneous workers' compensation, the injury had to occur or the hazard in the 2-year period prior to the filing of the application. What the board thought was that Crabb blurred that line a little bit. Of course, we can look at the 2-year period preceding the application, but that's not notice. That's just what the law says. The notice reflects back and refers back to the filing of a notice of injury or notice to the employer that it was injured. And that never occurred in this case. And that was one of the reasons why the board denied the case. Obviously, it's the Crabb decision that's before you, not the board's decision. But that was our only issue, is we didn't want that just to hang out there and to, expand this beyond what we believe is required. So if there are any other questions from the panel, I'll rest on our brief.
All right. Thank you.
Thank you.
Thank you both. These are always complicated, and it was really helpful briefing and argument. All right, we'll turn to the last case of the day, Connell versus Morrissey, number 24P 759. Counselor, whenever you're ready.
Good morning, Your Honors. May it please the Court, Michael Marcucci for William Connell. The trial court's decision here must be reversed because he reaches the decision only by mischaracterizing Mr. Connell's claim, mischaracterizing the harm alleged, mischaracterizing the complaint's allegations of knowledge, and mischaracterizing Mr. Connell's intent in seeking to enter into a prenuptial agreement. We allege clearly in the complaint, at Record Appendix 6, that what Connell alleges here is that Morrissey advised Connell that he did not need a prenuptial agreement to protect Connell's interest in the family trusts and certain other premarital assets in the event of a divorce, and that Morrissey misled Connell.
Could I interrupt you and ask
Yes.
this? If the allegations also include the fact that Mr. Connell's personal attorney recommended that a prenup was required, or an antenuptial agreement was required, and if I understand correctly, the allegation is that Mr. Connell believed Morrissey and implicitly disbelieved his own attorney? Is that the...
I think the sequence here is important, Your Honor, because I think that's one of the inferences the court impermissibly drew, which is that Connell's personal attorney, after the meetings with Morrissey, continued to believe and recommend a prenuptial agreement as necessary to protect the trust.
It doesn't say one way or the other. It says the personal attorney transmitted Mr. Morrissey's representations or advice back to Mr. Connell, correct?
That's right, Your Honor. And so the statement that Connell's personal attorney made to Mr. Morrissey was not a privileged communication. And so the complaint alleges that that's what was discussed in the communication with Morrissey. It's clear that from what's alleged in the complaint in the record, that recommendation preceded the meetings with Morrissey. And one of the core mistakes that the trial court makes here, whether it's a mistake or a mischaracterization, is that it assumed that Connell's view and Connell's knowledge and his view was the same after meeting with Morrissey as it was before, right? Connell said he wanted the trust assets protected, right? And as a layman going to talk about this, he thought a prenuptial agreement was the way to do that.
These are sole discretion trusts, right?
As we've alleged, these are contingent trusts. The beneficial interests are contingent upon events outside of Connell's control. The trust instruments are not in the record.
Right, but your complaint says they're sole discretion trusts, right?
Yes, Your Honor.
So they really aren't touchable in the divorce case unless with this fraudulent transfer thing. Isn't that correct?
Look, we think the divorce case is not resolved yet. It's pending in Connecticut. And it's certainly Mr. Connell's position that the trusts and his beneficial interests should not be reached in the divorce. And because of that, and because some of the injury here or the damages here will flow from the outcome of the divorce case, as we allege, we had suggested tolling the claims in this case until the divorce resolved. Mr. Morrissey declined.
You know, what I don't understand is if the theory is fraudulent transfers, that would kill a prenup, right? I mean, if you were fraudulently hiding assets going into the marriage, a prenup would be unenforceable, right?
As the theory in the underlying divorce case?
Well, I understand as far as your complaint says, maybe I'm missing something, the only theory under which these trusts can be touched is under this fraudulent conveyance theory, which would also A prenup wouldn't be any help against that, right?
If the assets were related and disclosed and finally conveyed, again, I'm not an expert on Connecticut law on prenuptial agreements, but certainly there could be litigation over the prenuptial agreement in the divorce case as well. And it's still possible, Your Honor, that it will turn out that Morrissey was correct and that he did not need this prenuptial agreement. And that will certainly present, if this decision is reversed, as we think it should be, that'll present its own factual question as to what's left of this case if Connell wins in Connecticut.
I guess I'm having a hard time understanding the harm of extra litigation fees, how that's in any way connected as far as the allegations of your complaint to anything that Morrissey said. If the theory is fraudulent transfer, that applies just as well to the trusts as to the prenuptial. So where does to the extent his advice was these trusts are iron tight, your complaint seems to say that advice was completely right.
Look, Mr. Connell thinks they should be airtight and he should win. The issue we have in terms of filing the complaint is under the statute of limitations case law, there is law that says when you start expending legal fees to dispute an issue, your harm may attach. And so when we were looking at this issue, there was a concern that Morrissey would argue that once the litigation goes to the trusts in Connecticut, then there's a risk that because you are spending money to litigate those issues, you now know there's a chance that Morrissey was wrong, right? You are now on actual notice in August of 2020 that these trusts may not be airtight and that you may have needed a prenuptial agreement and he may be wrong. Our preference
But
was
if the
to hold
trusts are airtight,
well, the Connecticut court has not resolved that yet, Your Honor. I mean,
but your complaint says they're airtight. I mean, it says they're sole discretion trusts.
that would be true if the Connecticut court agrees with our interpretation of the trust. I mean, this is our factual allegation. This is Mr. Connell's position. We think it's correct. We think it should prevail. The Connecticut court has not resolved that issue yet. So that the trial in the divorce case is scheduled for October, and as far as I know, there's still an attempt to get into the trusts in Connecticut, and I don't know how the Connecticut divorce case is going to resolve it. I think those questions, though, Your Honor, as to this claim, go to causation and damages, right? It would be a defense for Morrissey to say, my advice was correct. They were airtight. It turned out my daughter or her lawyer were more litigious than I should have been, but I didn't say anything wrong, right? And so there's an argument that they could make. It's not the argument they made. There hasn't been harm yet, right?
So
I think that's Your Honor's point.
help me understand, and it's Connell, correct?
Connell, yes.
How does a statute of limitations not start to tick when he walks down that aisle without the prenup in hand?
Because he did not.
Because there's not something hidden, right? I mean, in maybe you could differentiate in it the breach of fiduciary duty versus the fraud. And I'm happy to hear that, but there was no pulling of punches. He's talking to everybody. So if there was a violation of fiduciary duty, when Mr. Connell walked down that aisle, it seems to me that the statute of limitations clock started to tick.
No, because if Morrissey was correct, he didn't need the prenup. Right? He walked down that aisle because he was told by a trustee of the trusts that you do not need a prenuptial agreement to keep these trusts out of a divorce.
But the breach, whether he gave good advice or bad legal advice, is still the breach of fiduciary duty, is that he's talking to two people, correct? Or am I incorrect in that analysis?
You're incorrect.
Okay, tell me
because
why.
The statute of limitations is accrued by harm to the beneficiary, not knowledge of the conflict. The trial court and Morrissey conflate knowledge of the conflict with harm. The injury is if the trusts were exposed in the event of a divorce.
Right, so why is the injury not, I shouldn't have been talking to both people. I breached the fiduciary duty, my fiduciary duty, by consulting with both my daughter and my future son-in-law, right? And then it's the extent of harm versus what I did wrong, whether I gave good legal advice or bad. Was that harm right then?
There was no harm at all if he's correct. In other words, if he didn't need that prenup, the advice was solid, and there's
Or a breach of fiduciary duty, even if he gave bad legal advice.
It's a little bit like negligence, Your Honor, right? You can drive around negligently, and if you don't hit anybody, nobody can sue you, right? So if he had, and I think if you think about, because the trial court had suggested that he could have brought a declaratory judgment action in 2006. Well, think about what that case would have said. The case would have said, Morrissey told me I don't need a prenup. He's the trustee. I trusted him. I relied on him. I agree with him. I'm happily married. I have no intention of getting divorced, but I would like a declaratory judgment in the event that someday we're going to get a divorce, and someday that in that divorce, my wife and future ex-wife in a divorce tries to reach the trust. I now have in my back pocket this declaratory judgment that Morrissey is liable for breach of fiduciary duty. I don't think that's a claim that a court should entertain, right? The state of play in 2006 is they're all on the same page. He didn't want a prenup, and one of the other inferences and mistakes the court made is he inferred that he wanted a prenup for all the benefits of the prenup, right? And the big assumption, frankly, that the court made that's wrong, and that Morrissey asked you to repeat, is that the prenup was the only way to protect these trusts, right? Connell did not say he wanted a prenup for all the benefits. He just wanted to make sure that the business his father had built, that money, the family assets, were excluded. He was assured by a trustee of the trust, someone who had been in his life, his entire adult life, someone with eminent credentials, that there was no risk. He had nothing to worry about. So there's no harm to him. When we allege in the complaint, he accepted what Morrissey said. So when the court recharacterizes that and says, no, he knew he wasn't getting a prenup, he knew he wasn't getting a prenup because he didn't think he needed one. And so if he had filed the hypothetical declaratory judgment action that the trial court suggested, it would have just been dismissed. There's no case. The plaintiff and the defendant agree.
This is a question that I actually don't know the answer to. I know it's actual knowledge for the breach of fiduciary duty count. Is it constructive knowledge for the fraud and gross negligence counts?
I think the parties all agree that it's the same standard given the fiduciary relationship between the parties. So I don't think there's been a suggestion either by either party that there's a difference on any of the three counts, given the nature of the undisputed fiduciary relationship. I think once you remove, and to your questions, Justice Ditkoff, once you remove the assumption that a prenuptial agreement was the only way to protect the trusts, the rest of the decision sort of falls away, right? Because he knew he didn't have one, but he also didn't necessarily need one. And we cited the Fanninsteel case in the SJC, which very clearly lays out in Massachusetts that an expectancy from a trust is not included in the marital estate, and you have to examine the trust instrument to determine it. And if the Connecticut court does that in this divorce action, and I have no reason to think Connecticut law is different, but it could be, I'm not a Connecticut lawyer, then it will turn out that Morrissey was correct. And then maybe we can't get the legal fees, maybe we can't, right? That becomes a causation and damages issue. But all of these other points that the court raises below in recharacterizing the harm, recharacterizing the claim, recharacterizing the intent, which you can't do on a motion to dismiss, right? They have to draw the inferences in favor of Mr. Connell. And here it's not even the inferences, right? We alleged directly in the complaint that he accepted.
How far has the Connecticut divorce gotten? How far, where's the
The last I heard, there is a trial date in October. It's taken kind of a torturous path, largely because of the intent to bring the trustees from Massachusetts into that case, the trustees of these trusts. My understanding, and this is just my understanding of the state of play, is that the trustees in Connecticut were dismissed on the basis of lack of personal jurisdiction. There was an appeal taken, and that Pamela has dismissed the appeal. So as I understand it, as of now, the trustees are out of the Connecticut case, and that is going to proceed to trial in October. Now, that does not prevent, as I understand it, the court including the beneficial interests in the trusts as part of the marital estate, if whatever the analysis is under Connecticut law, but the trustees are no longer a party.
It sounds like we're in no danger of the right to recover in this lawsuit being assigned any time before we decide it.
It seems unlikely, Your Honor. I think so. And I think it does raise, because Mr. Connell is not, he still believes the trust shouldn't be touched, correct? But obviously, it's become a much more litigious and difficult issue in that Connecticut case. And we think ultimately that this case fits very comfortably within Massachusetts case law on the accrual of claims against fiduciaries, right? These are almost all decisions after trial, after summary judgment, right? Doe versus Harbor Schools is one of the big decisions here. That was on summary judgment. And the SJC made clear one of the key parts of there was the plaintiff's deposition, right? The Tachi case, which we think is a good case for us because there's almost 20 years between the events involved there in the lawsuit. The two brothers had suspicions of what their brother had done, but because they did not know about the specific conversions at issue, the clock didn't start to run until they learned about the actual breaches that were involved in that case. And that's true here, right? If we were seeking the full benefits of a prenuptial agreement across the board, you'd have the trial court's decision would hold more water, but that was never the issue, right? This began with a layman saying, I want to protect the trusts, and I need a prenuptial agreement, and the court inferred, but it's not alleged, that his lawyer had recommended it to protect the trust. As far as the record is concerned, he may have just recommended it for all the benefits of a prenup, and because Mr. Connell was satisfied after the discussions with Morrissey that the trust assets, the family assets he was concerned about were protected, he went ahead with it, right? And that's what we're getting at here. And this is right in the wheelhouse. All of the public policy concerns the trial court had, this was right in the wheelhouse of Morrissey's fiduciary role. This is going to the trustee of the trusts with questions and issues about the trusts, not general life advice. Unless there are further questions, we'll rest on it.
All right, thank you very much. Counselor, whenever you're ready.
Good morning, Your Honors. May it please the Court, Jennifer Grace Miller here today on behalf of Robert J. Morrissey, the defendant in this action. The question before us, as we've already noted, Your Honors, is whether Mr. Connell in 2006, when he got married, had actual knowledge of the facts giving rise to his alleged injury. From the four corners of the complaint, it is clear that he did. So when he walked down that aisle in 2006, Mr. Connell knew four things. First, he knew that Mr. Morrissey was both his trustee and his future father-in-law. That particular conflict, where you had a fiduciary who was considering advice that involved the interests of his daughter, was, as the trial court put it, sort of open and notorious. It was clear to all involved. Everyone knew of the dual role that Mr. Morrissey was playing in that particular situation. In fact, it was likely that both Mr. Connell and his lawyer went to speak to Mr. Morrissey because he was Pamela's father. We know from the complaint that Mr. Connell first approached Pamela to ask her to enter into a prenuptial agreement because he was concerned about his trust assets. She said that she would follow her father's direction. They then proceeded to seek out Mr. Morrissey to determine what that direction might be. It was very clear to all of the parties, Mr. Connell and his lawyer, that there were dual roles being played by Mr. Morrissey in that instance.
But that's not a breach of fiduciary duty so far, right?
Well, it could be. I mean, it is presumed.
I mean, if I'm the trustee of a trust, my mother's the main beneficiary and I'm a residual beneficiary, I can still be a trustee. I just got to make sure all my decisions are in the interest of my mother and not my personal interest, right?
You have to overcome the presumption that there is a conflict when you both have a family member whose interests are at stake and you have some other beneficiary to whom you owe a duty of loyalty. And in this instance, there was a presumption of a conflict because it involved both Mr. Morrissey's daughter's interest and Mr. Connell's interest as beneficiary. So I would argue that literally, and I'll get to the other three things he knew, but I would argue that the day after the wedding, he could have filed a lawsuit for breach of fiduciary duty because of the advice given under the presumption of a conflict. So the second thing that Mr. Connell knew when he walked down that aisle was that he had asked for...
Do you have a case that says that a fiduciary who's completely loyal to who they're supposed to be loyal to but has a conflict, that you can sue them for that even if they act solely in the interest of who they're a fiduciary for?
Well, the argument here is that he didn't act solely to the benefit of the beneficiary, that it was a conflict and that he gave advice that better suited his daughter's interests.
I get that, but would would Connell have known that at that time?
Well, he knew of the conflict. His lawyer certainly knew of the conflict, and it was an obvious conflict. There's no requirement that the beneficiary have a lawyerly knowledge of the legal consequences of a fact. All that's required is that they know that there was a fact. And as I stated earlier, it was open and obvious of this dual role that Mr. Morrissey was playing. Second, Mr. Connell knew that he wanted and had asked for specifically a prenup to protect his trust assets. That is a very specific kind of knowledge. He did not come to Mr. Morrissey and said, oh, I'm worried about my trust assets. How should I protect them in this impending marriage? He said, I want a prenuptial agreement. And he sent his lawyer, in addition, to say, Mr. Connell, in my opinion, I recommend that Mr. Connell enter into a prenuptial agreement before he gets married in order to protect his trust assets. And I really think that's the third thing. The third thing is that he knew his lawyer recommended that he enter into a prenuptial agreement to address his concerns about the trust agreement.
Even if that's true, though, why does it matter that, according to the complaint, Mr. Connell believed the advice that he received from Morrissey and implicitly rejected the advice that he received from his personal lawyer, putting the chronology aside? Why doesn't that matter where the actual knowledge test is involved?
Because he knew, based on the recommendation of his lawyer, that at least someone with disinterested professional recommended that he obtain this agreement in order to protect his trust assets. So at the very least, he knew that his lawyer said there was a risk to his trust assets if he did not have that prenuptial agreement. He walked down the aisle knowing that at least one professional had told him that he should have a prenuptial agreement.
Maybe this is splitting hairs, or maybe I'm completely missing the point. Feel free to tell me. But even if that's the case, if he had two conflicting points of view but only believed one of them to be true, why is that not contradictory to the actual knowledge?
He needs only to know the facts giving rise to his claim.
But I don't get what his claim is. What's the lawsuit he can file the day after the wedding?
Is breach of fiduciary duty.
What's his damages?
Well, the damages may be relatively difficult, maybe more challenging to ascertain.
But are they existent at all?
Well, they could be. You have a trustee who arguably has acted against his beneficiary's interests. Perhaps that trustee should no longer be a trustee. Perhaps they should seek removal of that trustee, for example.
I'm just having a hard time finding the harm the day after the wedding.
Well, the harm the day after the wedding is that there was advice that the beneficiary acted upon that in getting married without a prenuptial agreement, and the that advice was the result of an inherent conflict, and was to the benefit of...
That doesn't sound like harm. That sounds like a thing, but until the marriage starts going south, how is he harmed by that? Let's say it's terrible advice.
Well, it's no different from the claim they brought currently. They brought a declaratory judgment claim, as the trial court noted, without their ultimate damages being resolved. There's a divorce action, and it may very well be that these assets are protected, but they've had to spend some money, whatever. The knowledge of the extent of the injury is not yet known. And it is true that it would not yet be known the day after the wedding, but the elements of the claim would be the same.
It seems like, at least I'm getting stuck on, what does Connell have to have actual knowledge or notice of? And you say just basic facts that Mr. Morrissey he's not hiding it, he's upfront, everybody knows, he's father-in-law and he's trustee. So he doesn't need to know that the advice being given about the prenup is against his best interest. He just needs to know of a conflict.
Correct. He just needs to know of a conflict.
To equate to fiduciary duty versus actual notice or knowledge of the underlying harm.
Well, in this is what makes this case particularly unique. But I would argue that the difference in this case from perhaps a run-of-the-mill fiduciary case is that it contains within the four corners of the complaint an allegation that says he got separate legal advice. Who we believed, I mean, this is Filson, this is Tedesca. You got advice from an outside person that says that you at least are running the risk of this particular harm.
Yeah, I mean, you've got fantastic defenses. But that's not a statute of limitation defense, is it?
No, but it is actually, because it is part of the actual knowledge. The courts have said on statute of limitations grounds that if you have advice from an outside professional, that matters in the statute of limitations analysis.
But wouldn't the outside lawyer have had to say something like, you've got a claim already?
No, all he had to do, in our view, is that he recommended to Mr. Connell that he obtain a prenuptial agreement to protect his trust assets. That's what the complaint says. That was the recommendation. So he knew that. And of course, we know from Doe, right, ultimately, that there has to be a balance between being solicitous of beneficiaries, obviously, given the duty of loyalty owed by trustees and other fiduciaries, right? So that's on one side. And on the other side is an effort, policy that the Commonwealth does not want fiduciaries to be never-ending potential defendants. They don't want fiduciaries to bank potential claims against their trustees. So that's the balance. The balance is they have to have actual knowledge of the facts, not the legal consequences, not the extent of the harm, but of the facts giving rise to the alleged injury.
So the fiduciary duty violation, if it occurred when he gave the information saying no prenup. Does the fraud analysis change? So between count 1 and count 2?
I don't believe so, Your Honor.
Because the first is open and obvious, right? And when Morrissey says you don't need a prenup and you relied upon it, that's when actual knowledge occurs.
Correct.
Is your position.
That's my position.
But on count 2, where there's a claim of fraud, does that change?
They're all based on the same series of facts,
But
Your
wouldn't
Honor.
the advice for fraud, the advice would have to be actually wrong,
The
right?
advice would have to actually be wrong.
And
if there was fraud.
how would we get actual knowledge the advice was wrong? I mean, even today, never mind, 3 years before the filing. I mean, I don't know that we know what's wrong now.
Right. So actually wrong would obviously be some challenge, but there would be, given the facts, you would have separate dueling experts, presumably, given these circumstances. You would be able to prove whether or not a reasonable fiduciary in these circumstances would give this advice or that advice. And if it's that advice and it's clear that he should have known it was that advice and he was attempting to conceal something, then obviously that's how you would do it.
You agree with your friend that it's actual knowledge for all the counts and not
Yes,
just, okay.
we do.
That's helpful. I sure could have found that myself, but I didn't.
No, more than fine. Are there any other questions from the panel?
No, thank you.
Thank you very much, Your Honor.
This is a really interesting case. It was really helpful briefing and argument. And Mr. Marcucci, I know you're a very experienced appellate lawyer, but I think it was the first time we've had the pleasure. And we're grateful to have you. We hope you will see you here again. And with that, I'd like to thank our court officers. I'd like to thank our timekeeper. I'd like to thank all the attorneys who appeared in front of us. And with all that said, the court will stand adjourned until 3:30 p.m. in the Hale courtroom.